Okay, this presentation is about same-sex couples adoption law reform. And let's just jump straight into it. This law reform is called the Adoption Amendment Same-Sex Couples Act 2010, New South Wales. The first point to make about this law reform is that laws that govern adoption are state laws. So one of the things that we'll be talking about when looking at this law reform is some of the inconsistencies in adoption laws across the states. And when we look at adoption in more detail in an upcoming topic, we will see how this is becoming quite a concern. But this particular reform, the Adoption Amendment, Same-Sex Couples Act 2010 New South Wales, amended the Adoption Act 2000 New South Wales. So the Adoption Act 2000 New South Wales is the main adoption law in New South Wales. But what this law reform did was it actually allowed same-sex couples to become eligible to adopt children in New South Wales from 2010. So it was quite a significant law reform. This law reform obviously then has several strengths. The most important strength is that it recognised that same-sex couples who could already be foster parents would also be able to adopt children. So it actually was the case prior to this law reform that same-sex couples could be foster parents of children, but they were not able to adopt. So by introducing this law reform, there was a removal of discrimination from the law and a recognition that same-sex parents can still be in the best interests of a child. And at the same time, the law reform tried to protect the interests of religious segments of the community by allowing there to be exemptions for religious adoption agencies such as Anglicare and Catholic Care, so that these agencies are not required to comply with the law reform. In other words, they don't have to facilitate same-sex adoptions. So this is an attempt to meet the values of a particular section of the community. The other strength of this law has been shown through the court's role in determining what the best interests of the child is in adoption cases. So the first case that applied this law reform was called William and Jane 2010. And in this case, the court made it clear that same-sex couples should be assessed on equal grounds as any other couple when deciding whether adoption is in the best interests of the child. So to go into this case in a bit more detail, William and Jane was the first case involving same-sex adoption since the Adoption Amendment Same-Sex Couples Act 2010 reformed the Adoption Act 2000. In this case, the court had to decide several issues, including whether the adoption of William and Jane by their current same-sex foster parents was in the best interests of the children. And although the court noted that same-sex adoptions might conflict with the morals of some members of the community, it confirmed that same-sex adoption does not require what they called a specially cautious approach compared with adoption by heterosexual couples. So really, the fundamental principle is whether or not the adoption is in the best interest of the child. And regardless whether it is a heterosexual couple or a same-sex couple, it does not require a specially cautious approach for same-sex couples to adopt children. So in this case, the court found that the adoption was legal because of the 2010 amendment, and also in this case in the best interests of the child. This is discussed in an article at the time. Body language said it all. First same-sex couple to adopt in New South Wales are great dads, Sydney Morning Herald 2010. So this also highlights the role of the court. And when we talk about the court in adoption cases, we are actually talking about the New South Wales Supreme Court, because this is the court that deals with adoption as this is a state law. A more recent case occurred in 2016, the recent case of FACS, as in Family and Community Services, versus HR and CD. In this case, the court demonstrated that the best interests of the child are paramount in adoption cases once again, including cases of same-sex adoption. Specifically, in this case, it was made clear that the biological parent's opposition to their child's same-sex adoption, based on their religious beliefs, doesn't prevent compliance with the law reform. In other words, the child being adopted to a same-sex couple, if this is in the best interests of the child. So specifically in this case, the biological parents of the child, known as CJD, opposed the adoption of their child to same-sex foster parents. And this was because they were concerned that the adoptive parents wouldn't be able to raise the child as Catholic. The Supreme Court of New South Wales allowed the adoption, however, and they made it clear that Of course, cultural and religious ties should be preserved as far as possible. However, these do not sit equally alongside the best interests of the child. And this was discussed in a good news article for you to include called Adoption by Same-Sex Couple Opposed Because of Birth Parents' Catholic Faith. And that's from Sydney Morning Herald 2017. So that is a good article to include in the strengths, showing the role of the courts in facilitating and clarifying how this law reform actually operates. Now, when you talk about the limitations of this reform, you're not so much talking about there being a problem with this law, but what you can talk about, firstly, is the time taken or the delay in having this law reform actually realised. Because the first point that you can note is that the New South Wales Law Reform Commission actually recommended that this law be introduced in 1997. So it took 13 or 14 years since that recommendation for this law reform to actually be introduced. So you could argue that the law wasn't very responsive to the changing values of society or to the removal of discrimination. And then the other limitation that you can talk about says more about the operation of state-based laws in Australia rather than this law itself. So while New South Wales reformed the law in 2010, other state jurisdictions have taken a lot longer to do so. And what this does is it shows us that recognition of same-sex relationships has actually been quite slow and inconsistent, and this is due to the state-based nature of adoption laws. So a good example from 2018 is that the Northern Territory has only legalised same-sex adoption in March 2018. This was discussed in a recent article, Same-Sex Adoption Laws Pass in Northern Territory After Personal Debate on Parliament Floor, Sydney Morning Herald 2018. And in that article, the Deputy Chief Minister for the Northern Territory stated it was a shame that it had taken so long to change the laws. So when you give the limitations of the New South Wales law reform, you're talking more about the inconsistency of state-based laws dealing with same-sex couples adoption. Now, we can also talk about a range of non-legal responses when we're talking about this reform. Firstly, we can always talk about the media as a non-legal response. So articles such as those we've talked about previously can raise awareness about the need for law reform and place pressure on governments to change the law. But of course, the media cannot directly change the law. And secondly, we can talk about the Australian NGO Barnardo's Australia. This is a child protection and adoption charity. It played a role in supporting the introduction of the New South Wales law reform, and it made a submission to the parliamentary inquiry about the issue, advocating for its introduction. And it also actually acted on behalf of the adoptive parents in the case Facts versus HR and CD 2016 that we talked about earlier. In that case, Barnardo's submitted that it was not in the child's best interest to be baptised or christened because the child's CJD's adoptive parents would not be able to facilitate her involvement and development with Catholicism because of their sexual orientation. And ultimately, the court agreed with this approach. So this shows the role of Barnardo's in facilitating law reform and contributing to the end of discrimination and individual rights. While Barnardo's cannot directly change or enforce the law, it has been effective in its role for advocating the best interests of the child and the recognition of same-sex relationships. So where can you put this in the syllabus? Where does it fit in the syllabus? Well, it fits under numerous sections. It will fit under alternative family relationships, adoption, the contemporary issues of recognising same-sex relationships, the changing nature of parental responsibility, the care and protection of children. It also shows us the difficulty of defining family and the changing nature or concepts of family. And it gives us some information about distinguishing between state and federal jurisdictions in family law. And it gives us a wide range of legal and non-legal responses. Also, like always, law reform, cooperation and conflict, compliance and non-compliance, changing values and just outcomes, and the effectiveness of legal and non-legal responses are all demonstrated in this case study.